Melissa in Hackensack, New Jersey. Melissa.
Good afternoon, Brad. My name is Melissa. Yeah, I'm good. I have a question and I want to ask you. My brother is filing for my niece, and they request that they should get a DNA testing or to provide some documents because his name was had to their birth certificate like 16 years after the birth.
Right. Yeah, they basically, if you are a man filing for your child and you as a man were never married to the mother, they make you jump through 5 additional hoops versus if a married man were to file for his child. So because the father's name was not added to the child's birth certificate at the time of birth, they talk about, you'll see in the RFE that they say they want evidence that is contemporaneous with the events that you are trying. They say something to the effect, we want evidence that is contemporaneous with the events that you're trying to prove, which is basically saying we want proof that when this child was born, this father admitted he was the father, which is his name was put on the birth certificate or some other additional evidence. Now you have to prove not only that he is the biological father, but that he's had a relationship with that child between birth and 18 years old or whatever, how old that child is at this point. So.
Yeah, but the thing that is bothering us now is that the child, my brother, been migrated from he was in his teens because he got the child when he was in his teens. He migrated at then. He only visited Jamaica once because the child was taken by child care in Jamaica because the mother wasn't able to take care of the child. So the child reached of age now and is out of the government agency.
So let me finish my answer because I was about to answer that. Okay. So not only do you have to prove that you're the biological father and you put your name on at the birth or perhaps take a blood test, you have to show a parent-child relationship between birth and 18. Your brother-in-law migrated to America as a teenager, never really had a relationship, it sounds like, with this child ever. Didn't send money to support this child because the Jamaican...
Yes, he did send, he sent money now.
What you have to show that you sent money between birth and 18. And what you're telling me is that the Jamaican, child agency took this child under its care because nobody was caring for this child. The father wasn't caring for this child. The mother abandoned this child. For all intents and purposes, the father abandoned the child too, unless I don't understand the story properly.
No, what happened was the child, because my mother had the child, but the mother...
Did the father ever visit the child? Did the father ever have pictures with the child? Was the father's name on the child's student records as the person to contact if the child gets hurt or injured, or to even send the grades to? Do we have proof that the father sent money? The father abandoned the child.
No.
Abandoned the child. There's no evidence that this father had any relationship with this child other than every so often the father would fly home and say hi, or every so often maybe you would send money, but we have no evidence of it.
Okay, so is it a problem that he would be able to...
in those situations. It's not. The law says absentee fathers can't file for their children. Got to show a relationship. Now maybe you can. I don't know, but what you're telling me is something different. All right, so hold on. Let's go to Alana in Phoenix, Arizona. Alana.
Hi.
Hi, how are you?
I was married. I'm great. I was married to a U.S. citizen, but because of domestic violence, I had to flee with my son. He had filed for...
You had to what with your son?
To flee with my son.
Flee, okay.
He had initially filed for me and my son.
Right.
But after I ended up in a domestic violence shelter, I filed for myself under VAWA.
Okay.
My question is, because I'm not hearing any updates on VAWA, is there anything updated with VAWA right now?
What do you mean updated? It's the same VAWA laws.
I hear about DACA, I can hear about TPS, I hear about everything else, but nobody talks about VAWA applicants.
Because VAWA, you filed a VAWA case, VAWA exists. So what you're hearing in the news is that so as a VAWA, as somebody who is the victim of a crime, you're eligible for a green card. There's no law to change on that. DACA recipients are not eligible for green cards. TPS are not eligible for green cards. Those are the laws that people want to change. Now, the problem with VAWA is the problem with U visas, is the problem with adjustments of status, is the problems with I-751s, is the problem with every case that is being filed with immigration this year, which is immigration's not doing their job. They're just piling up applications and nothing's happening. So it has nothing to do with law changes. It has to do with we got to get resources to immigration so they can do their job. That's hopefully going to be an issue that gets resolved when they change the immigration laws.
I'm hoping. My prima facie expires next month.
Yeah. All right, hang in there. It's a 2-year process.
Thank you.
Right now. Okay. Thanks for watching. For more Bradshaw Live, like and subscribe to our YouTube channel.